Hello everyone, this is Pridarshini Tiwari. Today I am with you to discuss on the subject Code of Civil Procedure 1908. The topic for today's discussion is reference. So in this lecture I will be dealing with the introduction, the conditions for reference and the procedure in case of reference. Let's start with introduction. Part 8 of the Code of Civil Procedure deals with the provisions related to reference and revision. Section 113 and Order 46 of Code of Civil Procedure deal with the concept of reference. A court subordinate to the High Court is empowered to refer the case under Section 113. The court in relation to Section 113 means a court having original civil jurisdiction. A reference can be made only where there is a question of law or validity of any act or ordinance or of any provisions of the act is involved and can be sought only in a pending suit, appeal, or other proceedings. Section 100 By the virtue of Section 113, a subordinate court may refer a case for the opinion of High Court when some doubt arises on question of law. And a reference must be made in the case of non-appealable cases. Reference must be made before passing of a judgment. The court can refer either suo motu or on application by any party. An application for reference can be made either on the application of any party concerned or it can be made upon the own initiative of the lower court. A tribunal has no power to make a reference. A reference can be made only in a suit, appeal, or execution proceeding pending before the court. And where any matter involving a substantial question of law is referred by the subordinate court to the High Court for its opinion upon the matter, it is known as reference. According to Section 113, any court can refer the case to the High Court for its opinion, and the High Court may then make an order as it deems fit, subject to certain conditions and limitations. But such case must involve a question as to validity of any act or ordinance. Such question must have actually arisen between the parties litigating and the court must have been called upon to adjudicate. So, the reference can only be made when any question as to validity of any act or ordinance has been actually arisen between the parties litigating, and the determination of such question of law is necessary for the proper disposal of the case. The referring court must prima facie satisfy that such ordinance or regulation is ultra vires. Before making an application for reference, the referring court must have a satisfaction that such act or regulation is ultra vires, but it has not been declared as ultra vires by any higher authority, that is Supreme Court or High Court. Now the conditions for an application of reference. The first condition is that there must be a pending suit or appeal in which the decree is not appealable or pending execution proceedings. A reference can only be made when any matter is pending before any lower court, when any original suit or any appeal is pending before any original court, any original lower court. A question of law or usage having the force of law must arise. To prefer an application for reference, it is very necessary that any question of law or usage have arisen, and the determination of such question is necessary for the proper disposal of the case. The third condition is that the court must entertain a reasonable doubt on such question. It means the court who is dealing with the matter must have a doubt that particular case involves any question as to validity of any law or ordinance. It can be related to validity of any act or regulation. The question which have actually arisen between the parties must be related to any act, ordinance or regulation. It is necessary to decide such question to dispose the case, and for the proper disposal of the case, the determination of such issue is essential. The court must satisfy that impugned act, regulation is ultra vires. There is no determination either by Supreme Court or High Court that such act is ultra vires. The court must have also an opinion that particular act, ordinance or regulation has not been yet decided unconstitutional or void by High Court or any of the by Supreme Court or any of the High Court. High Court cannot make any order on merits nor can make suggestions. High Court may answer the question referred or can refuse or even quash it. It is the power of the High Court. High Court may answer the question referred before it, or he can refuse to answer, or it have also the right to quash such question. Now the procedure in case of reference. The court must draw a statement of facts, question of law on which opinion is sought. When a reference petition has been made before High Court, the High Court, after hearing the parties, if they so desire, shall decide the point so referred and transmit the copy of judgment to referring court for such disposal. If any case has been referred before High Court, the High Court after hearing both the parties will decide the question came before it for determination and shall furnish a copy of the decision to the referring court, directing such court to dispose the case accordingly. The High Court has the power to return the case for amendment. If High Court thinks fit, he can return the case to make any amendment in such particular case. The High Court may alter, cancel, set aside any decree or order passed by referring court and make such order as it thinks fit. While entertaining any petition of reference, the High Court have power to make any alteration, any cancellation, or they have also power to set aside any decree which has been passed by lower court, and High Court can make a new order on such case. For unwarranted reference, the High Court can direct the concerned judge to pay personally. High Court may either stay the proceeding or pass a decree or order contingent upon it. Article 228 of Constitution of India transfer of cases to High Court, but especially as to interpretation of Constitution, and can't even instigate into such questions. Thank you.